All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Welcome to the Arizona Court of Appeals. This is Woodbridge Structured Funding versus the Arizona Lottery, case number CR2 Welcome. For council's information, these proceedings are being recorded. Each side will have 20 minutes to present your arguments, so when you come up to the podium, there's a clock there, and that will tell you how much time you have remaining. The proceedings are being recorded both audio and visually, and so hopefully if everything goes right, you will be able to see yourselves on YouTube, have your 20 minutes of fame. Appellant, you may reserve a portion of your time for rebuttal, and if you want to reserve a portion of your time when you step up to the podium, if you'll tell us how much time you would like to reserve, we will try not to horn in on your time. Also, if the clock says you have 10 minutes, that 10 minutes includes your rebuttal time. So with that in mind, you may begin.
Well, good morning, and may it please the court, Bradley Pack appearing on behalf of the appellant, Gen X Capital Corporation. And I would like to reserve 5 minutes for rebuttal, and I'll do my best to keep track of that. Okay. Your Honors, one of the most fundamental elements of due process is the right to be heard and to meaningfully participate in any action that might affect a party's interest. In this case, Gen X and Woodbridge both asserted an interest in the same lottery payments that were the subject of the instant action to approve an assignment. By denying Gen X's motion to intervene so that it could assert its own superior right to those payments, and by entering a judgment directing the assignment of those payments to Woodbridge in Gen X's absence, the Superior Court deprived Gen X of its due process right to be heard.
Your position, counsel, is that your client's right was superior, yet you had not followed the statute in obtaining the affidavit and seeking court approval ahead of Woodbridge.
Well, that's part of the problem here, Your Honor, is that we weren't able to follow the statute because Mr. Thomas reneged on his agreement to take all the steps that were necessary in order to obtain the assignment of the lottery payments. And if I may, I'd like to briefly highlight for the court some of the key facts. I'm aware that the court is familiar with the record, but just the critical facts that I think go to the answer to that question. What happened in this case is that Mr. Thomas entered into an agreement with Gen X to assign his right to receive lottery payment annuities for a lump sum of $428,000. He received independent financial advice as required by the statute. And in fact, at the same time he sent back the signed contract to assign the lottery payments to Gen X, he also sent Gen X a confirmation that he had received that independent financial and tax advice. About 1 day after he sent that contract back to Gen X, he changed his mind. He entered into a contract where he purported to assign those lottery payments to Gen X's competitor, Woodbridge, in exchange for a mere $2,000 more.
So is it your position that he could or could not cancel the contract with you?
He could not.
So if he couldn't get out of the contract with you, what prevented you from filing the same type of proceeding that Woodbridge filed?
Well, fundamentally, Your Honor, that's exactly what we sought to do when we moved to intervene in this case. The statutory scheme requires three things, essentially, in order to obtain the approval of an assignment of lottery contracts. The lottery winner has to submit an affidavit stating that he's of sound mind and not acting under any duress, and the lottery winner also has to obtain independent financial and tax advice. The second one of those was certainly satisfied with respect to Gen X. The first of those, admittedly, was not with respect to Gen X because Mr. Thomas wouldn't give us an affidavit saying he wasn't under duress or he was of sound mind.
Well, it seems to me that then you really didn't have, according to, because the only way to assign these interests in the lottery proceedings is to have a valid court order. And so you couldn't, so any interest that you had at that point was really just contingent on the fulfillment of the requirements. You really don't have an interest in those those proceeds until you have a valid court order, though. Isn't that correct?
Well, I would agree, Your Honor, that before the assignment can be made effective and before the lottery will actually, under statute, before the lottery will order the assignment of the payments, you do have to have a court order. But we had the exact same interest in the lottery payments at the time this action was commenced as Woodbridge did.
Well, you couldn't if you didn't have the affidavit from Mr. Thomas. I mean, all you had was a signed contract. In order to get those proceedings, you have to have the affidavit, you have to file a lawsuit, you have to do the things that Woodbridge did in order to get an order. But you couldn't do that because you didn't have all the necessary documents in order to go to court and get a valid judicial order. So isn't your interest really just contingent at that point? It seems to me that you've got Mr. Thomas, who has signed a contract with you, but you don't have anything else that's required in order to be able to get the judicial order.
Well, respectfully, Your Honor, I would disagree. I don't think it was impossible for us to obtain that judicial order for this reason. We intervened so that we could obtain from Mr. Thomas under oath the statements that he was not acting under any duress and that he was of sound mind at the time that he entered into the contract with Gen X to assign those payments. There's no reason to believe that we would not have gotten that. We could have propounded discovery on Mr. Thomas, asking him to respond to written interrogatories, which he would be required to respond to under oath, stating that he wasn't under duress. Or
your ability to do that then was contingent on the court recognizing your request to intervene. I suspect in retrospect you'd probably agree that the easier way to get all that done would be to file your own lawsuit against Mr. Thomas and proceed in that fashion, and then perhaps move to consolidate the two rather than trust that the trial court would recognize your request to intervene.
Well, in fact, Your Honor, we did file a separate lawsuit and asked to consolidate it. We filed a lawsuit for breach of contract.
Yes, but that was, 30 days later?
Understood, Your Honor, but I think if we were to file an entirely separate lawsuit, one, we have no control over the timing of how quickly the instant approval action was going to move, and as we've seen, it moved extraordinarily quickly. They filed their motion for summary judgment, I think, within 2 or 3 weeks after the lawsuit was filed, and then the court ruled on it within 14 days, with 17 days left, not even, well, including mailing time, probably 19 days before the time to actually respond to that summary judgment motion would have expired. So by filing an entirely separate action, then moving to consolidate it, I don't think there would have been any greater guarantee that we would have gotten what we wanted any quicker. Except that you could have moved with the same alacrity as Woodbridge. We could have, Your Honor, but I think we would be entirely at the mercy of how quickly the Superior Court judge assigned to our case would have moved our case along. And in fact, if we were going to be asking to consolidate the case, we would have to make that request to Judge Ray because he had the lower numbered case. So I think in all likelihood, we would have simply gotten the same result.
It seems to me that the cases in your briefs that require intervention are cases where the parties are disputing interests in an asset, interest in the subject matter of the lawsuit. But those are distinct from cases, I think, like this, where the intervener is saying if the two parties in the existing lawsuit are duking it out over a contract, and depending on how the court rules in that case, one of them is not going to be able to do a deal that it promised to do with me. That's what we have here. I thought I was kind of intrigued by the MasterCard case, the FIFA case that cited in the answering brief, and I didn't see a rebuttal to that in your reply, but the Second Circuit in that case says makes the point that the intervener, of course, has its lawsuit, has a separate right if because of the outcome of the existing lawsuit, the party that the intervener thinks it has a contract with is not able to perform that contract, the intervener has a claim over against that party. But the absence of the intervener doesn't affect the validity of the existing lawsuit, the merits of the existing lawsuit. And I'm wondering if you have a response to that, given that the existing lawsuit in this case was pretty simple under the statute, where the statutory requirements met.
Well, Your Honor, I think the distinction between this case and the MasterCard case is this is not simply about one party being able to do a contract with another party. Here we're talking about the right to receive a particular fund that really can't be replaced by a simple breach of contract action like the one that we've got pending and which we intend to pursue.
Well, how can it not be replaced if these things are bought and sold all the time? Actuaries can put a number on it, can't they?
Actuaries could, but I don't know who's going to be paying us. If the court, for example, if the court in our breach of contract action finds that we were entitled to receive the lottery payments, that Mr. Thomas had breached his agreement with us, or that Woodbridge had tortiously interfered with our contract by telling Mr. Thomas he had a right to renege when he didn't, all we're going to get is a piece of paper that says you have the right now to collect money from Mr. Thomas or from Woodbridge.
Well, you're conflating the destruction of a claim. In other words, if you can't intervene in the existing litigation, your remedy or claim disappears with the ability to collect on a claim, which is never the ability to collect is not something that's preserved in our law. So I think Judge Johnson's point is that in order for Gen X to have its claim, it will still have its claim regardless of what happens in the Woodbridge litigation. Your ability to collect ultimately on the claim may be impaired, but I don't think that's something that we're here to deal with.
Well, Your Honor, one of the elements of Rule 24A, and probably the most critical element, is that disposition of the lawsuit in the absence of the intervener would, as a practical matter, impair or impede the intervener's ability to protect its interest. And certainly that is the case here. Our interest was in receiving the lottery payments directly from the Arizona Lottery, or more properly, perhaps from the annuity company that issued the annuity to make those payments. There is no question, there's no real question that had the court, had Judge Ray agreed to assign those payments to us, we would have been paid. The annuity issuer is an A-rated insurance company, and their payments are guaranteed by the Arizona Lottery, which fortunately I don't think Arizona is at any major risk of defaulting on its debts. So we know that had the Superior Court allowed us to intervene and protect our interest in receiving the lottery payments directly in the instant approval action from which this appeal arose, if the court had ruled in our favor, we know that we would have been paid. We don't have that assurance in this separate lawsuit that we are maintaining for breach of contract or tortious interference.
The right to intervene has got 4 things that you looked at, and one of the things that you talked about is the applicant must show that his interests are adequately protected. But you have to meet all four of those, the timing, the a certain interest related to the party, and that the disposition of the action may impair or impede your ability to protect its interests, and that other parties would not adequately protect it. You have to meet all four of those, and so going back to the interest, which I think is really where your uphill battle is it seems to me that until you have, according to the statute, until you have the contract, the affidavit by Mr. Thomas, and a judicial order, you really just have a contingent interest in those claims, and not and not the type of interest that where intervention is mandated. Why am I wrong?
I don't think you're wrong, Your Honor, that our interest here was that our right to receive the assignment was contingent on getting a court order. But where I assert that we satisfy the interest requirement is there's nothing in Rule 24A that says your interest has to be 100% vested and complete at the time you move to intervene. If that were the case, I'm not sure intervention would ever be appropriate, because there wouldn't need to be an intervene. You've got a vested right. You don't have to do anything to earn that right. You can start getting it immediately. In a number of the cases that we cited in our brief, unfortunately, many of them are out of Arizona because there's just kind of a paucity of law in this area in Arizona, say exactly that, where an intervener claims an interest. For example, the Washington Mutual versus the FDIC case out of the District of Columbia Court. That an intervener's interest is obvious when he claims an interest in the property that's the subject matter of the lawsuit. Now, obviously, in order to establish our claim and our right to receive the lottery payments, we have to prove that all the elements of the statute are satisfied. But that's the precise purpose for which we sought to intervene in this case in the first place, to be able to establish those elements, which would include proving through Mr. Thomas's testimony, which would be taken under oath at a deposition, or which would be propounded in response to written interrogatories, all of which have the exact same force and effect of an affidavit.
Although in that case, the bank said, those were my assets. You mistakenly enveloped them in the sale document. So it wasn't a case that the bank had to prove something or had to hurdle a test or make a showing before it could say it did own them. It said it's somehow different from here, where further legal requirements needed to be met before that interest was certain.
Understood, Your Honor. Again, at the time that this lawsuit was filed, our interest, contingent or not, vested or not, was exactly the same type of interest that Woodbridge held. They had their affidavit, but they did not have a court order. And it is that court order that is a condition precedent to receiving the assignment of the payments. We didn't have a court order. They didn't have a court order. We both wanted it. We were entitled to intervene in order to assert that right. And respectfully, I see that I'm running low on time, so I'll reserve the rest of my time for rebuttal.
Thank you, Counsel.
May it please the court. My name is Deanie Ray. I'm an assistant attorney general, and I'm here representing the Arizona Lottery and Jeff Hatchmiller, the director of the Arizona Lottery. And our interest in this case is not the money. Our interest in this case is preserving the integrity of the statute and the integrity of the lottery. Our concern is that when you turn a basically non-adversarial proceeding into an adversarial proceeding, this will not benefit the state, the lottery, or the winner of the lottery. And it will undermine the policy behind Arizona Revised Statutes 5-563A3, which used to be 513A3. The purpose of that section, A3, is it's a consumer protection provision, and it's to protect lottery winners from being forced to assign their winnings against their will. And I think, though, that it's important to look at the entire statute, not just A3, but the entire statute, because you have to understand that the first part of the statute, which is A1 and 2, talk about assignments that are not voluntary. A3 is just talking about a voluntary assignment. That's all that proceeding involving Woodbridge was a voluntary assignment of lottery proceeds. If the lottery were to receive an appropriate judicial order in a contested proceeding, a more adversarial proceeding, we would do the same thing that we would do if we receive an order in a voluntary assignment. The difference being is that the contested proceeding would be more adversarial, or it would be an adjudicated type proceeding, such as a garnishment, a breach of contract, tax liens, something of that nature. We would follow that order just as much as we would follow an order under the voluntary assignment proceeding. What Gen X, or the appellant, is asking for is to be allowed to come into the voluntary assignment portion proceeding and turn it into an adversarial proceeding, into a non-voluntary assignment. I mean, that is the ultimate conclusion that you have to come to, is that had they been allowed to intervene, they would have been involved in a fully adversarial proceeding in which they're presenting testimony, they're taking depositions, they're getting discovery. That's not what that proceeding was designed to do.
Well, counsel, you surely can't be suggesting that the statute is only for the uncontested assignments. It pretty much is window dressing, if that's the case. I mean, how do you respond to a Gen X's argument that as a matter of practicalities, if the Woodbridge assignment was approved by the court, Gen X was SOL?
I don't agree that Gen X was SOL. The minute Mr. Thomas reneged or rescinded the contract, rightly or wrongly, Gen X then had a breach of contract action. That would have been the appropriate, and is the appropriate, he has that action, they still are maintaining it. That is the appropriate remedy that he has. To claim that the res is going to disappear is not a valid claim under the facts. First of all, the lottery owns the annuity. The lottery directs where that annuity is paid. It's paid in yearly installments of $40,000 a year. So to this point, perhaps $80,000 of that res has been paid to Woodbridge. But the res is still there. It's still owned by the lottery, actually. It's not owned by Mr. Thomas. It's not owned by Woodbridge. It's owned by the lottery. The lottery directs how that will be paid. In the case of a breach of contract action, if we receive an order that says you're going to pay this to Gen X as opposed to Woodbridge, we'll do it. That's the way it works. But I don't believe that their ability to collect has been very significantly impaired. And I mean, it's the same thing as saying the annuity company could go bankrupt as well. I mean, these kinds of things can happen. But as far as a remedy is concerned, as far as the ability to collect is concerned, Gen X is more protected than most people in a contract dispute, because everybody can go bankrupt. So I don't see how proceeding under the contract action or the breach of contract action is a poorer remedy than trying to come in under a 563A3 proceeding and turning that into an adversarial action. For me, or for the state, the interpretation of the statute is that 563A1 little c is what controls his action, which is the Gen X's action, which is a breach of contract action. And had we, at the end of that, if we receive an appropriate judicial order that says this should be paid to Gen X, we'll pay it to Gen X. That's the way that works. Now, I intended in my argument to reserve considerable time for co-counsel, and I think the main point that I want to bring up is that this statute is designed, this part of the statute, just this portion, the voluntary assignment portion, is designed to protect the lottery winner. It's not designed to protect the assignee. There are better ways to protect the assignee, one of which is the breach of contract action, which they have. Thank you.
Thank you, Counsel.
Good morning, Kevin Meyer from the firm Renault Cook, Torrey Massaros on behalf of Woodbridge and the Thomases. I'd like to begin by agreeing with everything that my co-appellee said. We do believe that 5-563 is designed to protect the lottery winner, and that's the way in which the statute should be interpreted. The 3 points I want to leave this court with today are, first of all, to agree with Judge Orozco that no right existed for Gen X to the payments until the approval was actually done under the statute. The second point is to suggest that even if this court believed there was an abuse of discretion in denying the intervention, remanding would be a futility, and there's no prejudice to Gen X on that point, so there should be no reversal. And finally, we would just simply disagree that there's any basis for attorney's fees on this appeal to Gen X, or to Woodbridge or Thomases for that matter. Let me go back and say that Judge Orozco, I agree. In fact, Gen X's contract, which is part of the appendix that was supplied by the Attorney General's office, in paragraph 3 specifically indicates and recognizes that their contractual rights are not firm and are not fully vested until such time as the approval action takes place. And that's the purpose of 563 is to protect the lottery winner, to make sure the lottery winner is making the transfer of payments to the company that it believes is appropriate. And that's why it's a declaratory judgment action. It's a very limited proceeding, and that's another reason why intervention isn't appropriate. This wasn't designed as a full action trying to litigate the rights of everyone. The statute is very limited. There's a very limited requirement for proof of what actually has to be shown. And in that situation, that's not the type of action that should have intervention and should be designed to try to figure out where the rights are. If a party has a claim that there was a breach of contract, then that should be decided by a breach of contract action, which is exactly what Gen X did first. And I think this goes a little bit towards the point that Judge Winthrop was making earlier. Essentially, Gen X has elected its remedy. Gen X first chose to file the damages action. They did not file an approval action. Gen X knew as early as mid-June that there was this competing claim. At least in their eyes, it would be a competing claim. So they knew that Woodbridge was intending to make a claim. They knew that Mr. Thomas had at least talked to another company. They didn't run and try to file a separate approval action. They waited. We filed our approval action. They filed a damages action, and then they sought to intervene. So really, what Gen X has done is they've elected their remedy, and that's what's going on in this case. That's the damages action. Judge Johnson, I agree that the cases don't really support this claim. We agree that MasterCard really demonstrates that when you have a fully protected remedy through a separate action, there's no reason to allow the intervention in that case. And again, if the judge in the approval action had allowed intervention, the judge in the approval action probably would have had to just defer until the damages action, where there's full discovery, where there's experts, where there's pending motions for summary judgment, is resolved. And so, again, if you were to remand this, that's really what the outcome would be, again, I would think. There would be no reason to start over the discovery process and allow that to continue in a separate action. Again, Judge Winthrop, I agree that money is fungible and that you're not trying to protect a right to recovery. You're trying to protect a right to have the action preserved and heard. I think the damages action does that. As my co-counsel from the Attorney General office has said, if an order needs to be crafted in the damages action to redirect payments, that can be done easily, and then the difference can be made up fairly quickly. These are financial services companies, and they have access to annuity payments and can purchase those just as easily as the lottery can. And so there really is no detriment or no second best recovery options in the damages action. Finally, I would just like to say that there's no basis for attorney's fees against Mr. Thomas because what GenX sought to do in this case was intervene in a declaratory judgment action. That's really not contemplated by whatever contract they think they had with Mr. Thomas. To the extent that they seek attorney's fees against the Woodbridge Company, they had no contract with the Woodbridge Company, so there would be no basis for attorney's fees on that point as well. And unless the court has further questions. Thank you.
Your Honors, I'd like to address a few of the points made by both the lottery and by Woodbridge. First, the Lotteries Council made the argument that the statute is set up to adjudicate voluntary assignments of lottery payments. The assignment that Thomas made to GenX was a voluntary assignment of the lottery payments. Nobody forced him to sign that contract to us saying, I'm going to sell you the right to receive this stream of payments in exchange for a lump sum. The statute does preclude the type of involuntary payments, like, for example, if Mr. Thomas caused a car wreck and somebody filed a PI lawsuit against him and then tried to garnish the payments he was entitled to receive from the lottery, that's the type of involuntary assignment that the statute is designed to prevent, kind of like a spendthrift clause in a trust agreement. That's not the case here. Mr. Thomas simply wanted to have it both ways. He wanted to voluntarily assign his payments to two people, and the statute does not allow that. Second, Lotteries Council made the statement that, hey, look, we have the same type of remedy in the damages action as we could get here because the lottery payments are still out there. There's still a stream of payments that are being made. First of all, the same amount of the money is not all there because some of those payments have been dispersed. Second, Woodbridge isn't receiving those payments right now either. As part of the judgment, Woodbridge actually had the court assign the lottery payments to somebody else. In fact, they did it twice. Their original judgment assigned it to one company. The amended judgment assigned it to a different company. That said, if Woodbridge wants to stipulate that to the extent we get a judgment against them in the approval in the damages action, we have the right to collect that money from their assignee, from the money that they are receiving from the Arizona Lottery. Frankly, I think that would go a long way to resolving our concerns, but I'm not quite sure that this is the forum to be doing that. And for that reason, we think we're entitled to receive those payments directly. We were entitled to make that claim in the Superior Court, and because it refused, because it denied our motion to intervene to do that, our rights were denied, and the denial of the motion to intervene and the judgment entered in our absence should be reversed. Mr. Meyer characterizes this action as a declaratory judgment action. It's not. The Superior Court didn't say, okay, Thomas, you were of sound mind. I think you weren't pressured into entering into this agreement, and that's it. The Superior Court actually made an order assigning those lottery payments directly to Woodbridge's assignee, which per se put those payments out of GenX's reach. And for that reason, our interests were impaired. All the elements of Rule 24A are satisfied here. The Superior Court erred as a matter of law in denying our motion to intervene, and accordingly, the judgment that was entered in our absence should be reversed. Thank you.
Thank you, counsel. Thank you, both sides, for your arguments. We will take the matter under advisement, issue an order in due course. We're going to recess briefly to let you guys leave, next party come up, and we'll be back.